So you can start.
వచ్చింది యూట్యూబ్ వచ్చింది రంజన్.
Yes, sir. Yes. You can start, sir.
One second. Yes.
Good morning, everyone. There is a small video presented by college. Let's all have a look at the college presentation. Video is presented, a small video.
Welcome to AMC Educational Institutions, Bannerghatta Road, Bengaluru. This video will get you through the health and safety protocols practiced at AMC campus. Before you enter our campus, make sure you wear a protective mask that covers your mouth and nose. Sanitize properly at the sanitization station provided. Get your temperature checked and logged. For students and parents who wish to visit our campus for new admissions, head to the administrative block. When you enter the counseling lounge, you will be guided to sit in a designated area which complies with social distancing norms. Avoid close contact with another person. Our counselors follow a rigorous sanitization routine and check for temperature, and fatigue. We request our employees and students to follow the safety protocol meticulously. Look out for the yellow-black floor markers to prevent overcrowding. Sanitization stations are located in key communal areas for easy access. Common areas and touch points like classrooms, staff rooms, and door handles are regularly disinfected using medical grade products. We are doing all we can to keep you safe and healthy. We look forward to seeing you at AMC.
Good morning, everyone.
Good
I
morning.
would like to start the day with a quote given by a famous scientist, Dr. APJ Abdul Kalam. Dream is not the thing you see in sleep, but is that thing that does not let you sleep. A hearty welcome to all for today's webinar on intellectual property rights, patent filing procedures. Well, before we start the session, I would like to bring a few points to the notice of all the participants. I request all the participants to ping the questions in the Q&A box, which will be answered at the end of the session, and kindly keep your audio muted. Feedback form will be mailed to your registered mail IDs in 24 hours after this webinar, and e-certificate will be generated after you fill the feedback form. I kindly request all the participants to keep the chat box open only for technical discussions. It gives me immense pleasure to introduce our Honorable Principal, Dr. Prakash Duvri sir, who has done MSc from Osmania University, PhD from Devi Ahilya University, Indore, specialized in plant biotechnology. He has been credited with many national and international publications and also many awards during his portfolio. He has been associated with AMC College from 2 decades and has been the backbone in the development of the college. Now, I request our Honorable Principal, Dr. Prakash Duvri sir, Administrative Management College, to address the webinar. Over to you, sir.
Thank you, madam. Good afternoon to one and all participating in today's webinar. Respected Dr. Ramesh Shabhatkar, Professor, Ambo University, Ethiopia, the speaker for today's webinar. Head Dr. P. Sudharani, madam, Department of Biotechnology, AMC College, faculty members, AMC, other faculty members, participants, scientific fraternity, teaching community, and participants in this webinar, and the students. Good afternoon once again, and the people who are participating in this webinar. A brief introduction about the college I would like to give in 1 minute. Administrative Management College, institution with a brand name as AMC, was one of the first few private colleges affiliated to Bangalore University, began its journey in the sector of education for imparting quality education to the society and by offering undergraduate and postgraduate programs in management, computer applications, hotel management, aviation management, commerce, and biotechnology. By meeting the required standards of quality procedures, the institution is accredited by National Assessment and Accreditation Council, NAC, Government of India. A large conglomerate in education sector, AMC educational institutions impart education through 4 schools, through 2 PU colleges, 2 engineering colleges, 2 colleges offering general degree and PG programs, established itself as one of the largest educational groups in South Bangalore for over 3.5 decades. COVID-19 situation worldwide and also in our country made us to change the mode of learning from conventional classroom teaching to the present online mode of education. However, we are not apart. With the implementation of technology, we can be connected with each other. So please visit our site elearn.amcgroup.edu.in for the details for forthcoming webinar events. The present topic for discussion is intellectual property rights, patent filing procedures, a very promising area for discussion. A very large voluminous information and knowledge is available on this topic, and I personally feel that the topic needs thorough discussions and there is a need to educate the scientific fraternity in this direction. with special emphasis on IPR rules and regulations and also the patent filing procedures. To deliberate on the topic, we have Dr. Ramesh Shabatkar, a professor at Ambo University, Ethiopia, is with us and is MTech and PhD in computer science for the past almost 3 decades, taught various subjects in areas of computer science and information technology. Dr. Shabatkar is an academician, academic leader, patent researcher with core competencies in various areas of teaching, mentoring, career counseling, faculty development, curriculum development, team management, peer mentoring activities, academic motivator, academic content development, skill and competency development, student counseling, and brand building of the institutions. Vast experience at various capacities at university, engineering colleges, corporate training areas on intellectual property rights. Dr. Shabatkar developed key interest with core competency as patent consultant, patent analyst, attending US-based clients. He was into core academics, training students at engineering, undergraduate and postgraduate levels, with focus on research and development and several publications in national and international journals. He is also a member of various professional bodies, member of Indian Society for Technical Education, life member of Computer Society of India, member of Institute of Electrical and Electronics Engineers. His lecture on intellectual property rights, patent filing procedures shall add value and knowledge to the participants of this webinar. With present situation of COVID pandemic, I appeal to all of you, not to become panic and stay safe, stay clean, use masks, following social and physical distance, and don't waste your time and keep learning. So I once again welcome all the participants and also my friend Dr. Ramesh Shabatkar from Ethiopia, and also from the teaching and scientific fraternity for this webinar. Thank you very much. And I request Dr. Ramesh Shabatkar to take over on the topic, and over to Dr. Ramesh. Thank you, sir.
Yeah. So thank you very much for your kind introduction. Thank you very much for that. And many thanks to AMC management and the whole team of AMC to give me an opportunity to become speaker on intellectual property rights, patent filing procedure. I hope I'm audible, sir, to all of you.
Yes, sir. Yes. Yes.
Yeah. Shall I go ahead, sir?
Please.
Shall I go ahead?
Yes.
Yeah. So today's topic is intellectual property rights, patent filing procedure. It's not only patent filing procedure. I'll touch you on the various services which I was part of it in the international corporate arena. So that's how the focus of discussion is going to be today. And as we all know, as the name property comes into the picture, normally the people who are fascinated towards acquiring various properties like land, gold, or any form of property which they feel valuable to them, they start acquiring that. But the biggest property, what a human can have, which is given by the God himself to every human being, is the brain, which pursues knowledge, and knowledge becomes an intellectual property. Now, the intellectual property, which is acquired over a period of time, and most of the people who are educated these days, and the parents invest lots of money in making their child to become highly knowledgeable. The reason for them is to train the child to have full knowledge about anything which is happening, which is going to transform their life. So that's how the knowledge is being disseminated to the children of any parents. And that becomes in turn the intellectual property. But the intellectual property cannot be spoken in public, just the sensitive matters of the knowledge. So it needs protection. So protection can be done in 5 classes. In any country, you can take the complete jurisdiction of this planet. It is normally done in patents, copyrights, trademarks, industrial designs, and geographical indications. I'll touch upon each one of them as we proceed further. So basically, we need to ponder more on having a knowledge which gets converted into a property. Apart from your other regular properties, what you are giving more value to it. Intellectual property, as you increase, rather the knowledge as you increase, it is going to increase abundantly, unlike any other property. Let us say I use land, the day I end up no land. I use cash, or I use gold, or I use any form of property, which if I use, I have got a fear of losing them or emptying them. Whereas knowledge which got converted into an intellectual property is going to increase as you use it. So which is the best property? The best property is intellectual property, what I feel personally. And we are all, as a teachers or knowledge industry people, we all witnessed in our life that as I use my knowledge quotient, it gave me a good results in life. So that's how we have been witnessing. Sorry, you have to move the slide if you don't mind, so that the slide also, if you can make me visible, it will be great. Yeah. Go to the second slide, sir. Slide number 2. Make it full screen and go to the next slide. Yeah. This, yeah, this should be. Press, yeah, hold it there, sir. Now, let me touch upon each of the topic, what I mentioned. Patents, a government authority or a license, sir, go back to the previous slide, Previous slide, please.
Yes, sir. Yes, sir.
Patents, you be there, sir. Patents.
Yes, yes.
Yeah. A government authority or a license confirming agency, which can give you a right on a title for a period of time so that you can make, use, and sell an invention, which you have right on to that. And this is one of the things which is shown as a diagram. Normally in the biological sciences or other core sciences, the inventions used to happen in the olden time. So that's how the pictures have been shown in the olden time. So this is a shot which you can correlate to any of your technologies which you are part of it. Let's say you can belong to engineering stream or a biotechnology or any sort of technology you belong to. What is that you can file as a patent? There are patentable matter and what is non-patentable matter. At the end, I'll touch upon a little bit on biotechnologies which are patentable and non-patentable on a outer shell. So that's how I'm going to touch upon at the end of this slide. That is my last presentation slide, which is going to be. Go to the next slide, sir. Next slide, please. Next slide, please. Yeah, talking about copyright, an exclusive and assignable legal right is given to an originator for printing, publishing, performing, filming, recording literary or artistic or musical material. A typical example of the movies have been shown. Next is trademark, a symbol or a word or a words which are legally registered or established by representing a company or a product. In this case, we are showing about Coca-Cola as a trademark register. Next slide, sir. Next slide, please. Industrial design slide I need. Industrial design protection is protected for a shape, configuration, surface, pattern, color, or a line combination, which are basically applied to the aesthetics looks of a particular design in two-dimensional or three-dimensional. Let us say you look any article today, which are in the form of two-dimensional or three-dimensional, which are visible, which we are using in our day-to-day lives. All of them fall in the category of industrial designs. Next is geographical indications. Geographical indications. Next slide, please. Next slide. Geographical indicators, as the pictures talks about, the food grains what you grow or the spirits which are grown, which are filed as a geographical indicators. If you take Ethiopia as a country, which is producing coffee as one of its original product, which is going to be the source of geographical indicators in Ethiopia. Likewise, various countries will have their own geographical indicators which are exported to the various part of the world, which they are prominently producers of the same. So that is how the geography under protection in the intellectual property. Next slide. Next slide, please. Now, this patent is not a new thing to Indians if you go by. In the 1856, February 28, the first patent filed by George Alfred D. Penning in Calcutta, who is a civil engineer, and it is on Pankha pulling machine, which is given a number 1856, the number one patent, an efficient Pankha pulling machine, which went on to become a social need in the future, and which he himself secured many other productive patents in his long life of professional. Go to the next slide, sir. Next slide will tell you how physically he used to appear along with the design what he filed. This is what is George Alfred D. Penning on the left side, and the design which he filed is visible on the right side. It's a design patent basically. Next slide will tell you the exact application about this particular patent which was filed in 1856, which went on to serve the humanity in, let us say, church. There used to be a pankha which is put in, where the people come for a prayer many other days. This is how the inventions are helping the society to transform their way of living. So that's how patents are, or any form of intellectual property is going to help us in forming our lives much better. As you have seen, the world has revolutionized on internet, your smartphones, and various other services these days. Due to COVID, we are able to get connected virtually, being in different part of the world. So this is are helping us in connecting ourselves across the world. So these are the proven technological advancements which are helping the society, like you take Zoom or a Google Meet or Cisco WebEx or even GoToMeeting. These are connecting us from any part of the world today. Now, we lag by 2.5 hours compared to Indian time, but still we are managed to speak to each other and on the topic of patents or any topic which we are willing to. So this is how the technological disruptions are helping us which are going to be protected as a patent. And in turn, there's a huge revenue models which are being displayed in this particular field, which I'll touch upon in one of the particular case. Go to the next slide, Chad. Now, if you talk about what a patent normally when we draft, typically what it contains, I'll be touching upon that. We call it as specification. So it is called as contents of the specification. It should have a title of the invention, which we feel and apt to describe that particular invention. We've put it as a title of the invention. Then field of the invention, which briefly describes about in just what this invention is going to achieve in terms of a problem. Technically prior art in the industry. So there is a service line which is going to talk about prior art search, which most of the engineering graduates can get a job ranging from 5 to 6 lakh rupees to begin with as a prior art search, which is called as a patent analyst job. Then object of the invention, summary of the invention, brief description of the drawings if any, detailed description of the invention, examples related to the invention. Claims and abstract are part of the complete specification, but they are not required in the provisional application. A patent can be filed in two versions. One is provisional and another one is the complete. Provisional will give a timeline of 1 year, wherein you thought about an invention which you feel can be protected. You file it as a provisional application. You can take 1 year of time to completely consolidate what is known as a complete specification. If you do not file complete specification, your application gets abandoned with only provisional specification. Now, claims and abstract need not be the part of the provisional, but claims are the heart of your invention, where the rejections from the patent office are done mainly onto the claims, and even the revenue models are done on the claims only. There's no part of the specification which can fall into the category of revenue model over your claims, especially onto the corporate patent war. So that's how the whole idea about the specification goes into. Next slide, please. Press one more. Press 2 times. Yeah. No. Go back. No. Criteria for patentability. Many people will ask, can I file this as a patent? Can I file that as a patent? There are common questions fall into the category. So there are three classes which you have to pass through, which is novel. No prior use or a claim or a publication of any of the matter which is part into the global world, which is visible. Second one is industrial utility, capable of being made or used in the industry. Non-obviousness, let's say a particular person is a person skilled in the art who's an expert. For him, the matter what we are talking about, he should feel it is non-obvious. If he feels obvious, that's one of the criteria where you feel it is non-patentable. You should have a technical advancement with economic significance. I hope I'm pretty clear here. What is the criteria for a patentability? It should be novel, it should have an industrial utility, it should be non-obviousness. And there are patent laws which fall into novel and non-obviousness. If you go by US patent laws, it's about 102, what we call it as. Under that, again, A2, maybe K, Z, up to that. The subsection of the legality will tell us that based on this clause, this is not novel or this is novel. Similarly, non-obviousness falls in the category of 103. Again, you will have a subsections into that, which tells you to say that this is non-obvious or this is obvious. On that front, your claims are getting rejected from the patent office. Then you need to prove yourself again that this matter is highly novel and non-obvious, which has a more industrial impact onto that in future. So that's how my claims how to be given a patent. That should be your justification. Next slide, please. Now, as I mentioned you, there are provisional and complete specification which are filed in the country of origin where you belong. Let's say we are all Indians. First, let me file a patent in India as a provisional for initially, or we can file directly complete as well if your attorney or the agent is capable of handling your invention. Let's say I file my patent in India today, that is 24th August 2020. That becomes a priority date in 6 months to 1 year, which I'm going to file the same application in other part of the world, maybe 140 countries, where the invention has got a potential business model in that particular jurisdiction. Now, let's say I file in Australia or in US or UK or Europe or Canada. The 24 August 2020, what I filed today, will be the priority date over the filing date, which is going to be the next year in that country. But still, the invention is going to get the date, which is priority date of today, which is filed in India. Then after filing, you need to publish your application. In the olden days, it used to take 18 months. But nowadays, due to expedition, we have got capable of getting in a week or a month of time, we can publish our application, which is made visible to the whole world, so that you can have a pre-grant opposition. Pre-grant opposition is the one which tells us that somebody who have thought about what I have thought, which I'm filing as a patent, can say that this is my thought I had filed already, or I had an evidence of thinking like this. So you cannot own this particular invention. So if that is the scenario, then you can have a pre-grant opposition. But nowadays, expedition of examination is also yielding us within a year or 18 months of time, we are getting our grant of the patent. Recently, I could get this particular example about it. Then, if you go by the olden timelines, after 18 months, you will get an examination report, which is called as first examination report. And you will go through multiple examination reports if your claims are not carrying any strength to be patentable. Then it may take ideally about 48 months to get a grant of your patent. But some of them have gone up to 10 years to get the grant of the patent because of the pre-grant oppositions. Now, ideally, if you get in 4 years, then there is a post-grant opposition, which is going to be said, wherein I was part of 150 cases in USPTO, where I have opposed for the grant which are given by USPTO, and most of them have been knocked out, saying that they were granted in not a right.
Hello, Ranjan. Hello.
Yes, sir.
Hello.
Hello.
Ranjan, some technical issue.
Sir, from their side only, sir. From sir side only.
Pardon?
From sir side only. From Ramesh sir side only. I think there is a problem.
Okay.
Yeah, go to the next slide.
Yes.
Next slide, please. Now, this particular flow chart is going to tell you what is the process which goes in the patent office. Normally, it is a black hole. Most of the people do not know what is happening inside the patent office. Let's say you file an application with a provisional specification. If complete specification is not filed, your application gets abandoned. Let's say you file a complete specification. Within 18 months, it gets published, and there's a pre-grant opposition. Then there is a hearing by the controller. If the opposition can be allowed or rejected. If it is rejected, then you can request for examination and go for the first examination report. Then reply the all first examination report by refiling the amended documents, which are going to say that your works are more novel and non-obvious and which have got industrial applications. Re-examination and issue of further objections. You can compile all of the objections and file them, and hearing by the controller will happen. And if all get through, then you get a grant of the patent. Let's say the objections are not compiled within 12 months, it gets abandoned. And there is a scenario wherein controller can refuse to listen to your objections. Then you can appeal to an appellate board called as IPAP. If IPAP refuses, then you can't do anything, your patent gets seized. Otherwise, if appeal is allowed, you can go for grant of the patent. Then grant publication. After this, post-grant opposition happen. If there is no opposition, demand for renewal fees you can pay. Renewal fees paid and you can continue 20 years. If renewal fee is not paid, again patent gets seized. Then after grant, the post-grant opposition, if it is coming into the picture, there's a constitution of opposition board is formed. Submit your report to the controller. He hears them. Then controller can allow the objections. And if it is not allowed, you can go to IPAB, get allowed your objections, and get back to pay the renewal fees for continuing your publication. If opposition is dismissed, if it is allowed, then you can't do anything where your patent gets into the. So this is the whole scene which happens inside the patent office, which normally attorneys and agents are handling. So that's why they have their own charges. We need to pay them so that they deal all of that. As an inventor, I give my inventive matters to agent or a patent agent or a patent attorney. So this is how the whole picture of a simple flowchart of how a application is filed till the grant of the application. Next slide, please. I worked with Vardhaman College of Engineering as a Dean Industry Institute Interaction. One of my portfolio was to file patents for the organization. I have filed 6 patents there, 2 for EC, 2 for CSC, 1 for mechanical, and 1 for organizational level, because the organization is running a hotel industry. So there also I filed on to 1 food industry. So this is how CSC branch, if you take, I am also part of the inventor, where I become inventor in them. Then there's the reference number and the date in which we filed. All of the patents are given on to the right side, with the inventor name on the left side being indicated. Next slide. Since I worked with Microsoft about 7 years, I had pulled out about 6 patents, which I was part of it. But there are more than hundreds of patents which I am part of for the Microsoft, heading the team of 200 engineers, wherein if you take up, Naren Attila is one of the inventors who filed a patent on system and method for integrating secure and non-secure software objects. The patent got granted and the grant number is 7650493. Filing date was 17/2/2006. I entered into the industry in the year 2005. So from there on, it started getting into. Then the grant came into the picture 19/1/2010. Likewise, if you look at other the inventions which have got grant number, which is 7-digit number in US, whereas 11-digit number if it is an application or a publication number. So that's the difference between grant and a application as well as a publication number. Then you have a methods and apparatus for handling single user applications in multi-user computing environment, determining email filtering type based on sender classification, social network mapping, server failure recovery, method and system for taskbar button interfaces. These are a couple of inventions. The engineers who are working part of the R&D team of Microsoft are the inventors, and some of them who are coming out of the other university professors or the students can be taking part of into that, which company feels their potential to be part of it. Then the advantage of becoming an inventor here, though the owner of the patent is Microsoft, is Microsoft is generous to give $10,000 per inventor. That's the caliber Microsoft carries. Unlike any other organization, of course, the other contender for Microsoft in those years was IBM. Then heading on to, I worked as a consultant to other companies like Nokia, Samsung, Siemens, and a crowdsourcing company, which is called as Article 1 Partners. Then it went on to become an UK-based company, RWS, which is acquired now in UK, where 2 million researchers were participating. And I am happy to share that my photographs was posted in the company for 3 years, from 2010 to 2013, since I was extremely doing well in those cases, which was floated by various companies across the world. So these are the big technological corporation related, which are product based in industry, which can become an API or a small patch of a software can be filed as a patent. So that's how software alone can be patentable in US, unlike India. In India, you need to have a hardware being used along with the software. Software need to put into some sort of an hardware. Hardware can be an electronic based or a mechanical based, or sometimes in any electrical or any branch of engineering which can fall into the classes of hardware. We can put a software into that, and that is patentable in India. So that's how it goes into. Next slide, please. Now, I will show you some forms which are required for Indian filing. These forms are part of the Indian Patent Office. Form 1 talks about application for patent grant. Form 2 talks about application for provisional or complete specification. This is the important form where you as an inventor have to contribute here. This is a little toughest form among all the forms. Rest all are procedural forms, like Form 3 is for statement and undertaking, Form 4 for request for extension of time, Form 5 for declaration as to inventorship, Form 6 for claim or request regarding any change in applicant or patent, Form 7 for notice of objection, Form 8 for request or claim for regarding mention of inventor as such in a patent, Form 9 request for publication. I was talking to you about early publication. Form 9 is used for early publication. It is possible by paying extra fees, you will get a publication date prior to the 18 months regular time. Form 10 talks about application for amendment of patent. Next slide. Form 11, application for direction of controller. Form 12 talks about request for grant on patent under section 26(1) and 5. Form 13, application for amendment of application for patent or complete specification. Form 14, notice of opposition to amendment, restoration, surrender of patent, grant of compulsory license or revision of terms thereof to correction of clerical errors. Form 15, application for restoration of patent. Form 16, application for registration of title, interest in a patent or share in it, or registration of any document purporting the effect of proprietorship of the patent. Form 17 talks about application of compulsory license. Next slide. 18 talks about request or express request for examination of application for patent. Form 19 talks about application for revocation of a patent for non-working. 20 talks about application for revision of terms and conditions of license. 21 request for termination of compulsory license. Likewise, there are so many forms which are available in all the countries. These form numbers are different for different action. It need not be the same in what we are dealing with India. It need not be the same in Australia or US or Canada or UK or Europe even. They change. Like there is a different classes of forms you will have. Next slide. In India, you have got 4 jurisdictions where you can approach to file a patent. Let's say patent office in Chennai and Mumbai. New Delhi and Calcutta. Chennai, who can go into? The states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the Union Territories of Pondicherry and Lakshadweep. Mumbai, the states of Maharashtra, Gujarat, Mandya, the Madhya Pradesh, Goa and Chhattisgarh, and Union Territories of Daman and Diu and Dadra Nagar Haveli. New Delhi, states of Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, Delhi and Union Territories of Chandigarh, Kolkata, rest of the India. So, you being South Indians, we can go to Chennai, unlike any other part of the place. Next slide. How you can file a patent application, either through online, which is called as e-filing, ipindiaonline.gov.in/online, or through a post, or by you can submit by hand even. Next slide. I was talking to you, I was part of a patent litigation in the year 2007, where I was a consultant to Lakshmi Kumar and Sridharan, which is a law firm in Delhi. And as we all know, in life, we have to do one good deed which can save us from the difficulties of the life, which Damodar Pariwal being one of the examples of that. He is a owner of a software3.com in New York. Unfortunately, he became a bankrupt by not running a business properly. But the advantage, what happened to him, is he filed one application in the year 23rd March 1998. Priority date is also same. Since he was a US citizen, he filed in US PTO. Publication happened in 2 years, December 19, 2000. Now, Oracle has started manufacturing and selling the products related to object relational mapping from 2000 to almost 2007. They made big billion business in the world, Oracle company. But this particular case from Acacia company, through Matthew Vella being the patent attorney, has come to Lakshmi Kumar and Sridharan, which is a Delhi-based law firm, where I am the primary investigator for this particular case. And we could knock this particular case in 4 months, capturing the claims of this particular invention, which is system and method for exchanging data and commands between object-oriented system and relational system. Though the title doesn't talk about what exactly the invention is going to, it is basically a Java objects being written to the SQL database. That's the invention actually, which Oracle was manufacturing and selling as a huge product, and the business model was in billions. So we approached and we could catch them onto the live stream, saying your more product features are mapping to the claims of this particular invention. Who is inventor is Damodar Pariwal, who's a Rajasthan-based human being. So as you know, unlike India, where citizens are not given a much care in Asian countries, whereas US, they care about every citizen who belongs to their country. Even president of US can drop down to the place where their citizens are there in the trouble and rescue them. So likewise, they put in saying, you are going to save your one of the nationals, you are saving your citizen. That's the emotion attached to that particular thing. So one of the proud moments to say that in my professional career, this is one of the biggest revenue model case. I could be part of it as a principal investigator to share with all of you along with my patent filing experience. Next slide. Two more press you have to do, two more, one more. Yeah. Now, as we all, since we talked about patent litigation, in the world, Apple and Samsung being the biggest business model which has taken place in the whole world, and the whole world has witnessed what a revenue has flown in between Apple and Samsung. Over 50 pending cases in at least 9 countries, and US litigation they have consolidated it to 5, whereas Samsung went on to win the cases in South Korea, Japan, France, Italy, UK, Germany, Netherlands, and Australia. Whereas Apple being one of the primary runner in US, they could see that the lots of revenues have been exchanged between each one of them. Next slide. Patent war. If you look at this particular slide, every company is fighting with every another company. If you see Kodak, RIM, LG, Microsoft, Oracle, Google, Motorola, Gemalto, Samsung, Pantech, Huawei Technologies, ZTE, Interdigital, Nokia, Vimatex. So likewise, there are n number of companies are fighting with each other because they say this is my first thought, which I thought about, and which is supposed to be coming onto my name as an inventor over your company R&D. So this is how the intellectual property has started making a huge business model in the world. So which is the biggest property, if you ask me? Like any other property will have a variations in terms of graphs of growth, whereas this particular property is only upward growth. There is no downward growth at all in this case. Smartphone competitor patent suits. This is one of the topic. If you look at various technologies, minutest details of every technologies are going to be part of this patent war, where you can really make lots of money, and Apple being the center of all of this. Next slide. If you look at Apple and Samsung, what it is saying on the left side, Apple is saying on the right side. Let me go through some of the patents. Patent 516 speaks about, which Samsung says, manages the phone's resources and battery by prioritizing data. Patent 941 talks about, provides a way to package and transmit data more efficiently. Patent 893 talks about switching between pictures in a gallery and the camera. Patent 460, taking and emailing pictures using a scroll action. Patent 711 talks about a method allowing multitasking while playing music on the phone. This is about some of the claims which Samsung is making. Apart from the US, they are managed to win. Whereas Apple says on the right side, patent 087 and 677 says the ornamental design of the iPhone is our claim. 305 talks about rounded square icons on an interface. 163 talks about enlarging documents by tapping the screen. Patent 915 talks about distinguishing between single touch and multi-touch gestures. Patent 381 talks about bounce back feature when scrolling beyond the edge of a page. Likewise, huge number of patents have been filed. If you go by Nano Motors, I was part of that particular case in the Tata Motors, where the Motors, rather Nano car, got around 41 patents for every part of their engine or every part of their vehicle. So like that, this smartphone has got enormous number of patents filed on every smallest feature, including ornamental design of the phone. Likewise, you can file your various applications. Next slide. Now, once you consolidated your patent, filed into the patent office, and you got the grant, then you look at manufacturers, prepare marketing material, submit marketing material to the manufacturers, negotiate the license if they are willing. If they don't want to take up your license, then they will be in trouble because already the grant of the patent is on your name. Then it gets into the patent litigation where every business what is being made, which is going to be part of it, you are liable for getting 20 to 30% of their whole business, which is going to be the same. So that's how it goes into the commercialization of this particular property. Next slide. Applications filed by Indian applicants state-wise, if you look at it, Maharashtra being the highest, 3,513, Tamil Nadu being the second, 2003, Karnataka is 1,764. Likewise, Himachal Pradesh is up to 40. That's how the patent filing happening in India state-wise. Next slide. The top 5 Indian applicants for patents are IIT collectively 400 applications. Then Wipro Limited around 226. CSIR is around 225. Mahindra and Mahindra is about 205. BHEL is around 174. Then since I belong to computer science, I put on information technology patent applicants list, which I put it. Whereas your branch of technology, we can consolidate in listing or the table who are the frontier in filing the patents in your field of technology. The Wipro being 190, Tata Consultancy is 159, IIT collectively 43, HCL is 35, Huawei Technology is 29 on IT field. Next slide. Top Indian applicants for patents in institutes and universities. IIT again 400, Amity University is 106, Indian Institute of Science is 54, which is supposed to be more in number. Valtech is around 50, Raisoni College of Engineering 49, Bharat University is around 45, Chandigarh Group of Colleges is 30, Chitkara University is around 29, Hindustan Institute of Technology and Science is 28, NITs put together 26. NITs also must back up in increasing the number. Next slide. See the top 10 applicants for PCT national phase. Now, national phase is, let us say you filed in India, being Indian citizen, then you want to file in various other countries your application where you see the business model in those part of the country. Let's say Ethiopia is a top grower of coffee, and they can go into capture the other part of the world where the coffee is grown or less grown or less in quality. They can make a business out of that, saying that we are the world premier. Likewise, USA being the top again with 8981 applications filed through national phase through PCT country-wise. Japan 3399, China is 2256, Germany is 2186, Netherlands is 1295, Switzerland is 1112, France is 1014, Korea is 998, UK is 920, Sweden is 809. So they are managed to see the other part of the land in the world to see that their businesses in various technologies can be part of it. Let me narrate one of the trademark conflict which I was part of it in Bangalore. There's an organization which is called as Wood Decor, which manufactures furnitures for more than 3 decades, and the business is very heavy in Bangalore. But there's another company which is also floating the same name called as Wood Decor, and they have started making business. Then over a period of time, what happened is the original company came to know that the another company is making business by putting our name. That's a conflict of trademark. Then both approach. Then we settled the case, and given the new name, since the lady who was running the second company was a Muslim, her name was Umas. So we made it as Umas Wood Decor as a new name for them. And 20% of their share of the business have to be given to the first, the company, Wood Decor. So that's how another trademark happens. If you go by trademark again, the worldwide mistake, what most of us we have seen or witnessed, is Xerox. Xerox is basically a company which manufactures some devices, but in the code of the law, still you can see the people writing, take 2 photocopies of your invention or your copies. That's how they write, which is actually not right. So that's how we need to be very careful in what lines we write. Since there was a request from your organization saying it is done for biotechnological department, so I need to touch upon patentable biotechnological invention. Briefly, let me touch upon some of the matter which are patentable for biotechnology, which is not there in the slide as such. I have pulled out from the web, which is from the patent office, which I'm going to tell you about it. Methods for producing or analyzing proteins and their use in an analysis method or in a medicinal product. This can be patentable. I repeat again, methods for producing or analyzing proteins and their use in an analysis method or in a medicinal product. This is patentable. Proteins, DNA sequences, microorganisms, and constituents of the human body, for example, cells, which are already exist in nature, if they are isolated from the natural environment or produced by a technical procedure and have not been described previously, this is also patentable. I repeat again, proteins, DNA sequences, microorganisms, and constituents of human body, for example, cells of the body, which are already exist in nature, if they are isolated from their natural environment or produced by a technical procedure and have not been described previously, which means it should be novel. A gene which is isolated and given a new task as a medicinal product or a diagnostic tool. This is the third one. A gene which is isolated and given a new task as a medicinal product or a diagnostic tool. Genetically modified products such as plants and animals. So these are patentable, which are displayed. The non-patentable biotechnological inventions are pure discoveries is non-patentable, such as discovered but not isolated or further described parts of animal, plants, and microorganisms. Non-patentable, pure discoveries such as discovered but not isolated or further described parts of animals, plants, and microorganisms. Plant varieties and animal breeds. For a definition of plant variety, there's a plant breeder rights protection that manual you have to refer in terms of plant varieties and animal breeds. There's a protection of plant breeder rights. There's an act which you need to read to consolidate your work. But that is also non-patentable. Inventions that are contrary to public order or morality, which society regards as unethical and unacceptable. For example, it is not possible to patent a method for reproductive human cloning as it is contrary to public order and morality. Here we can find more information in biotechnology and ethics in terms of manuals which are written onto them, that like that it goes into. So the inventions that are contrary to public order or morality, which society regards as unethical and unacceptable. For example, it is not possible to patent a method for reproductive human cloning. It is contrary to public order and morality. So this is how the whole scene of patentable action goes into. Then copyright, as you say, your software code alone can be patented in US and other part of the country, unlike India. Then your algorithms can be your copyrights. Your artistic material, let us say you've written a beautiful song, which can be copyrighted, or if you have written any literature, which can be copyrighted. Trademark, you want to run a company, you can float your own product, which can be trademark. Designs, nowadays, the tables and the chairs or the fans or the air conditioners or the building structures or the irons, which are part of your existence or fall into the design aspects of it, then you can file it as a design patent, as Alfred D. Penning has done for the Funka filling machine. Likewise, various classes of your knowledge can become an intellectual property, and in turn, any production, like two of the best invention, like R.A. Mashalkar being advisor to Prime Minister today, he was referring to best inventions wherein one girl was going to a school, and poor girl who has to travel some kilometers and come back and study, she was not able to wash her clothes because of study time. So what she has done, this particular need of the hour has given her an idea to make sure that she invented a machine which is what is called as a pedaling washing machine. So she used to pedal the washing machine and get clean her clothes. And in turn, it was presented to R. Mashalkar. He went on to take to Prime Minister of India. Then Prime Minister has referred to a company to manufacture this kind of washing machines, wherein the girl got 1% as a license, and 10,000 units or 1 lakh units have been produced. So the girl got around 10 lakh rupees as a licensing money. So this is how you can earn money through your thoughts, which you feel need of your time. And another girl, her grandparents were not able to climb the stairs of their home. So she has invented a product which is an adjustable legs of the four legs walker, wherein the old people can adjust by putting onto the stairs inside, wherein the duplex houses have the stairs inside. They can adjust and walk onto the stairs to go up and meet their people or spend some time onto the upper floor. So that is how the things have happened. So these are the few things to share with. And thank you very much. Next slide is thank you. So for giving me an opportunity for the AMC administration and the management and the principal sir, Prakash sir, and the whole team of biotechnology and the attendees. So I'm open for questions if you have got any of that.
Thank you very much, sir, for fascinating us with your excellent presentation on intellectual property rights and patent filing procedures. Sir, there are a few questions from participants. Would you like to answer it, sir?
Yeah, please.
Yeah. The first question is how one can protect IPR in a joint project?
Joint project, you mean different organizations?
Yes, sir. A kind of a question where they're present. It's in a joint project dimension.
Joint project, let us say AMC in tie-up with ISRO, or AMC in association with IASC, or AMC in association with any other R&D companies or a corporate or an institution. Let's say if this is the or IITs, this is possible. There's an MOU which you need to write, and power of attorneys are given, and the shares are also discussed before you getting into filing, where clear demarcation of the revenues will be decided, who will get what share in terms of commercialization. It is possible.
Thank you, sir. Sir, next question. What practical steps do someone have to take to obtain patent protection?
Yeah. Now, if you go by, as I listed out in my technology, as I belong to computer science, software alone is not patentable in India. And non-patentable in biotechnology, since biotechnology is hosting this event, I have listed out some of the non-patentable versions of as far as India is concerned. But they need not be the same if I go to other countries. They are different, like US, UK, Canada, or Europe, or Australia, or any part of the jurisdiction like Philippines or Singapore, any country. The laws are going to be different. So patent protection will have its own impact on the way in which you do it, on a legal terms of it.
Thank
I
you,
hope
sir.
I have answered your question.
Yes, thank you, sir. Sir, one last question I'll pick, sir. What are the measures, best measures on employee innovative output in firms? What are the best measures on employee innovative output in firms?
Yeah. Can I simplify your question by putting into a simple way of saying, like I am an employee of AMC, how do you measure my employee output? Is this is what you are looking at?
Yes, sir. I find it the same question. Yes, sir.
Let us say I am an employee of AMC. Let's say how much intellectual property I'm able to produce in a given year of 2 semesters in a year. Per semester, how much I'm able to. If you effectively do 2 patents per year, should be a good, reasonable, what do you call it as a performance from an employee perspective. I mean, people are unlimited in thinking. There are people who can file I was part of one particular company where the CEO had filed. He's a CEO of the company. He filed in about his 25 years of service. He filed around 3,000 patents. Then you can imagine he would have filed more than one patent in a given day. If you go by the number. Like there are many professors in IISc and IITs, they're holding about nearly 200 to 300 patents on their name in span of close to 30 years of service, which means their work output is very predominantly dominant in filing the patents in their arena of technology. So once the taste of that comes into, then the desire to do more and more of it, like our research papers or any publications which we do, is going to keep on increasing the desire of counting the numbers. As we all know, like any part of the game, if you take, as a cricketer, I want to have more centuries, more 50s, more numbers on my account as a batsman. As a bowler, I want to have more number of wickets. Likewise, as we all belong to knowledge industry, I want to have more number of patents on my name which are granted, not only published or applied.
Thank you very much, sir. Any more questions? I request participants to mail it to the mail ID mentioned in the Q&A box. As we have come to the end of the webinar, I would like to thank Almighty First in Place for making today's webinar possible. With immense pleasure, I would like to propose hearty vote of thanks to our guest speaker, Dr. Ramesh Shahbatkar, on behalf of our AMC College, for accepting our invitation and for devoting his precious time by giving an insightful presentation. Thank you very much, sir.
Thank you.
Our special thanks to Mr. Rahul Kalluri, sir, Executive Vice President, AMC City Group of Institutions, and all the members of the management for their great support in organizing this webinar. I take this opportunity to put all my gratitude into words to our respected Principal Dr. Prakash Duvri, sir, and our beloved HOD Dr. P. Sudharani, madam, for constantly supporting and encouraging us a lot to do our best in this webinar. I thank you both from the bottom of my heart in making this webinar possible.
Thank you, madam. Thank you.
Thank you, sir.
Thank you.
I'm also thankful to Mr. Ranjan Alashetty, Department of Commerce and Management, AMC College, for his kind cooperation in helping us with all the technicalities in conducting the smooth webinar. Our wholehearted thanks to all the participants and professors for joining us in this webinar with your patience hearing and made it possible by sparing your precious time for a beneficial cause. Thank you, everyone.
Thank you, sir. I'll keep in contact with you through mail. Yes,
Thank
and
you.
very informative
Thank you.
session, and I enjoyed your talk. Slides and the information is very good. Certainly, I'll keep in touch with you, sir. Thank you.
Thank you, sir.
Thank you.
Thank you.